3 local protesters facing like 6 years in federal prison, a sitting U.S. representative staring down a 17-year sentence, and a state judge arrested by the FBI right inside her own courthouse.
Yeah, right inside our chambers. It's wild.
It is. I mean, we are watching this unprecedented real-time collision between federal immigration enforcement and local authorities, and it is sending these constitutional shockwaves from, local city streets all the way up to the halls of Congress.
Right, because the legal framework that normally separates federal authority from state jurisdiction is being stress tested in ways we really haven't seen in modern American history.
Before we unpack how this is all happening, if you find these deep dives helpful, please take a quick second to like, subscribe, and turn on notifications so you never miss an update.
Yeah, it really helps out.
Also, I need to give a strict update on the Martin Stevens versus OpenAI matter. There are 4 facts to note here. First, it is not a lawsuit. Second, the matter is currently in a voluntary quiet period. Third, no settlement has been confirmed. And fourth, the dead man's switch has not been activated.
Right. Those are the confirmed facts as of today.
Yep. So let's get into today's mission. We are analyzing how the Trump administration's incredibly aggressive immigration policies are, well, sparking these massive legal battles.
And we pulled together a huge stack of highly polarized sources to map this out for you.
We did. We're looking at the right-leaning Chicago Contrarian and Fox News, the left-leaning Mother Jones and Range Media, plus some deep legal analysis from the Mike Bicker Law Blog, and national reporting from the New York Times and PBS.
And, because these sources contain really intense politically charged viewpoints from both the left and the right, we need to issue a firm reminder to you, the listener.
Always important.
Yeah. We are absolutely not taking sides or endorsing any of the viewpoints we discussed today. I mean, our only goal is to impartially report what is in the source material so you can understand the legal mechanics and really the arguments being made on all sides of this debate.
Right. So let's start at the ground level, because the legal definition of conspiracy is suddenly the hottest debate in the country right now. Let's look at the Spokane 3.
Yeah, that case is intense.
It really is.
Yeah.
So back in June 2025, activists Bajun Mavalwala II, Jack Archer, and Justice for All were protesting outside an ICE facility in Washington state.
Because ICE had detained 2 Venezuelan immigrants who, according to the sources, were actually in the U.S. legally.
Right, exactly. So fast forward to today, and those 3 activists were just found guilty by an all-white jury of felony conspiracy to impede or injure federal officers.
Which is massive.
It is. They're looking at a $250,000 fine and up to 6 years behind bars.
And if you look at the left-leaning sources, particularly Mother Jones and Range Media, they frame this conviction as a deliberate overreach by the federal government.
Well, 100%.
They emphasize that this wasn't, some pre-planned criminal syndicate. Activists describe it as a totally spontaneous community action that was sparked by just a single outraged Facebook post.
Well, and I was reading through that Mother Jones piece, and it struck me just how controversial the prosecution itself was internally.
Oh, right, the U.S. attorney.
Yeah, the original U.S. attorney for the region, Richard Barker, actually resigned rather than prosecute this case. He publicly stated that pursuing a 6-year conspiracy charge for a street protest just wasn't true to who he wanted to be as a prosecutor.
Which really tells you something about the internal pushback.
Exactly. And on top of that, the defense pointed to some deeply troubling behavior by law enforcement. Like, there was body cam footage of a deputy saying he wanted to hit someone with a stick.
Wow.
Yeah. And an ICE agent's racist social media posts were also brought up.
Right, but then you get a completely different framing when you look at the right-leaning Chicago Contrarian. They examine a very similar collision in Chicago.
With the alderman.
Yes, Alderman Jessie Fuentes. She was detained in a hospital emergency room because she was demanding to see a warrant from ICE agents who were executing Operation Midway.
And that was the targeted crackdown on that violent Venezuelan gang, right, Trinidad.
Exactly. And the Contrarian labels this kind of grassroots interference as literal mob action and criminal obstruction of justice.
They don't mince words.
Yeah.
They argue that when cities and local politicians openly defy federal law, they are turning into what they call criminal cities.
Which carries massive financial consequences, by the way. The Contrarian notes that the Trump administration responded to Chicago's defiance by utilizing a really specific mechanism.
A funding cut.
Right. Withholding critical federal funding. They pulled the federal grant money that was meant for the CTA red line expansion. They are literally using the power of the purse to force local compliance.
Okay, But let's unpack this conspiracy charge specifically, because, I mean, treating a spontaneous Facebook protest as a criminal conspiracy sounds a bit like being charged with plotting a bank heist just because you retweeted Robinhood.
That's a good way to put it.
Right. Like, where does the legal line for conspiracy actually begin?
So legally, a conspiracy requires two things. First, an agreement between two or more people to commit an illegal act, and second, taking some affirmative step toward committing it.
Okay.
The mechanism at play here is that federal prosecutors are aggressively utilizing the conspiracy charge because it fundamentally bypasses the need to prove you actually engaged in physical obstruction.
Wait, really?
Yeah, they don't have to prove you blocked a door or fought an agent. They just have to prove you agreed to a plan that would result in obstruction and then took a step toward it.
So, just showing up to the protest with a megaphone or, like, coordinating a carpool could be legally construed as the affirmative step in a criminal conspiracy.
That is the exact fear. Mother Jones notes that the government's evidence to prove this conspiracy included pictures of an activist holding a clipboard,
A clipboard.
and protesters linking arms, and even someone holding an umbrella, which prosecutors argued was a tactical tool to shield the group.
That is wild. Yeah.
Civil rights groups are warning this creates a severe chilling effect on the First Amendment. I mean, if the standard logistical tools of organizing a legal protest like clipboards, umbrellas, megaphones are framed in court as the physical mechanics of a criminal conspiracy, it makes everyday citizens terrified to exercise their right to assemble.
I can see why. But, if local activists and city aldermen are facing this kind of aggressive federal heat, what happens when a sitting member of the United States Congress physically steps between ICE and their targets?
Yeah, then it escalates from a civil rights dispute into a full-blown constitutional crisis.
Which is exactly what we're seeing play out with Representative LaMonica McIver, a Democrat from New Jersey.
Right.
The New York Times reported that last May, outside Delaney Hall in Newark, she was involved in this chaotic 68-second physical scuffle with ICE agents.
Over the mayor's arrest.
Yep. The agents were attempting to arrest Newark's mayor, Ross Baraka. And now, the Justice Department is charging a sitting member of Congress with assaulting and impeding federal agents.
The stakes there are just astronomical. Acting Attorney General Todd Blanche is aggressively pushing this prosecution.
Oh, yeah, and President Trump has publicly called Representative McIver out of control. Plus, she is facing a potential 17-year prison sentence.
Which is just staggering.
It is. But what makes this fascinating to me is her defense strategy. She is outright refusing any plea deal.
Oh, absolutely not taking a plea.
Right. Instead, her legal team is invoking the Constitution's speech or debate clause. She is arguing that because she was at that detention facility to conduct congressional oversight, she has absolute legislative immunity from this prosecution.
And to be fair, federal law heavily protects members of Congress when they are conducting oversight, which does legally include unannounced visits to immigration detention facilities.
Okay, but here's where it gets really interesting to me, though. I always thought the speech or debate clause just protected politicians from being sued for what they say at a microphone on the House or Senate floor.
Yeah, like it protects them from libel so they can debate freely.
Exactly. So how on earth can her lawyers take a clause meant for congressional speeches and apply it to a physical scuffle in a parking lot?
Well, former House counsel Stanley M. Brand noted in the New York Times that this is absolute vanguard legal territory. I mean, the clause has almost never been applied outside the physical boundaries of the Capitol or committee rooms.
Right.
But McIver's legal team, led by prominent Democratic lawyer Mark Elias, is building a very specific mechanical argument here. They argue that oversight is a core constitutionally mandated legislative function.
Okay.
Their logic is that you cannot physically decouple the act of inspecting a facility from the legislative process itself.
I see.
So if the executive branch can arrest a congressperson for the physical friction that occurs during an inspection, then the executive branch can effectively block Congress from doing its job.
Oh, wow. So it transforms a 68-second physical altercation into this massive constitutional stress test of executive power versus legislative immunity.
Exactly. And Elias is framing this as a purely political prosecution, drawing direct comparisons to the administration's past attempts to indict political foes. The core legal question becomes, can the executive branch weaponize criminal law to physically block the legislative branch from conducting its constitutionally mandated oversight?
And meanwhile, the personal toll on Representative McIver is just Staggering. The Times reports she is drowning in over $1 million in legal fees.
I can't even imagine.
She has actually had to lay off her entire campaign staff just to pay for her defense. And perhaps most revealing, she feels completely abandoned by many of her congressional colleagues who simply do not want to touch this controversy.
Yeah, it is a very lonely fight, but the precedent it sets will redefine the balance of power in Washington.
Absolutely. So we've got the executive branch flexing its authority against local citizens and clashing with the legislative branch, but they're also taking aim at the judicial branch.
Yes, which resulted in one of the most shocking visuals in modern legal history, honestly.
You're talking about the sitting Milwaukee County judge, Hannah Dugan.
Right.
She was arrested by the FBI right inside her own courthouse.
Just incredible.
The allegation was that she allowed an undocumented immigrant named Eduardo Flores Ruiz, who was in her court facing misdemeanor charges, to exit her courtroom through a non-public jury door. And the prosecution claims she did this specifically to help him evade an ICE warrant.
And the legal blog Mike Baker Law provided a really deep dive into the mechanics of her trial. So fast forward to February 2026.
Okay.
After hearing all the evidence, the jury came back with a highly unusual split verdict. They found Judge Dugan not guilty of concealment, but they found her guilty of obstruction.
Wait, I need to pause on this. If the jury legally decided she didn't hide it, like if she is innocent of concealment, how could she possibly be guilty of obstructing the arrest? That sounds legally impossible.
That's a really great question. The appeal hinges entirely on mens rea.
Criminal intent, right.
Exactly. The defense argues that if there was no concealment, because Flores Ruiz literally just walked out into a public hallway and was arrested 22 minutes later in plain sight, then the prosecution fundamentally failed to prove she had the corrupt intent required for an obstruction charge.
Makes sense.
The Mike Baker Law analysis argues that by acquitting her on concealment, the jury effectively destroyed the logical foundation needed for an obstruction conviction.
But beyond just the logic of the jury's verdict, there is a much deeper constitutional principle at play here regarding states' rights.
Oh, absolutely. It centers on the 10th Amendment and the anti-commandeering doctrine. This is a crucial distinction. An ICE warrant is an administrative warrant.
Okay, meaning what exactly?
It is essentially an interagency memo issued by an ICE officer. It is not a judicial warrant, which has to be signed by a neutral judge based on a demonstration of probable cause. Under the 10th Amendment, state judges and state courts are not required to enforce federal administrative edicts.
Meaning the federal government cannot commandeer local state resources like a judge or a local police force to do their federal police work for them.
Precisely. From the defense's perspective, Judge Duggan was simply managing the flow of exits in her courtroom, which is her absolute right under Wisconsin law.
Right.
The Ninth Circuit has actually established a legal principle that refusing to help is not the same thing as actively impeding.
Interesting.
Yeah. Declining to assist ICE agents who do not have a judicial warrant is a refusal to help. By sending the FBI to arrest a state judge, the defense argues the federal government is attempting to criminalize the very act of a state official not cooperating with a federal administrative priority.
The visual of a state judge being put in handcuffs in her own chambers over courtroom exit management is frankly terrifying. Now, we have been talking about local resistance to federal authority as if it's purely a left-wing sanctuary city phenomenon.
Right, but it's not.
No, it's not.
Right.
Legally, isn't this the exact same states' rights argument that far-right anti-government groups have been making for decades?
Yes, totally. To truly understand the legal mechanics of these conspiracy charges, we have to look at how they have been applied to the far right. The tension between local autonomy and federal power is not a partisan invention at all.
No, it is a deeply enduring American tradition. I mean, look at Ammon Bundy.
Oh, yeah. Perfect example.
In 2016, Bundy led an armed, anti-government militant occupation of the Malheur National Wildlife Refuge in Oregon.
And when you look at the federal charges brought against Bundy and his armed followers, they were the exact same federal conspiracy charges that the unarmed Spokane Three faced.
Conspiracy to impede federal officers.
Exactly. But there was a drastically different outcome in court. The Spokane Three, who organized a peaceful street protest, were convicted by a jury. Ammon Bundy and his armed militant followers who took over a federal building were acquitted by a jury.
And it gets even crazier. A Washington GOP representative, Matt Shea, was actually expelled from his own Republican caucus in 2019.
For his involvement, right?
Yes. A House report found his involvement in planning Bundy's armed standoff was so extreme it amounted to an act of domestic terrorism.
Wow.
So you have local lawmakers on the left, like MacGyver and Fuentes, facing federal charges or detention today for resisting federal authority. And you had a local lawmaker on the right, like Shea, facing expulsion for fighting federal authority just a few years ago.
It reveals an incredible ideological whiplash. I mean, both sides tend to scream about federal overreach and states' rights when they are the ones being targeted by the Department of Justice.
Naturally.
But those exact same sides will turn around and applaud aggressive federal crackdowns when the machinery of the state is aimed at their ideological opponents.
The hypocrisy is real. But speaking of Bundy, the update on his current status is fascinating.
Oh, what's going on with him now?
He recently led a far-right group called the People's Rights Network in a harassment campaign against St. Luke's Hospital in Idaho over a child welfare case.
Oh, I heard about this.
Yeah, he baselessly claimed the hospital and the state government were involved in a massive child trafficking ring. It got so severe, the hospital had to go on lockdown and actually divert ambulances away from the emergency room.
But the legal consequences finally caught up with him, right? Though it happened in civil court rather than criminal court?
They did. He was hit with a massive $52.5 million defamation judgment by a jury.
Wow, $52.5 million.
Yep. He ignored the court orders, refused to take down the defamatory posts, fled his home in Idaho to hide out in Utah, and then attempted to file for bankruptcy to legally erase his debt to the hospital.
And how did that go?
Well, a federal bankruptcy judge just stepped in and blocked that discharge.
Ah, okay. The judge utilized a very specific mechanism in the bankruptcy code. The law states that you cannot use the bankruptcy system to escape debts that were caused by willful and malicious injury.
Right.
Because the jury found Bundy intentionally orchestrated a campaign of harassment and defamation that actively endangered the hospital's operations, the bankruptcy judge ruled his financial liability cannot be discharged.
So he's on the hook.
He is. He cannot use federal bankruptcy protections to shield himself from the consequences of his local resistance.
So what does this all mean for you, the listener? Why should you care about a local protest in Spokane, a 68-second scuffle in a Newark parking lot, or a judge managing exits in Milwaukee?
It's all connected.
It really is. Because the outcomes of these specific hyperlocal cases are actively redrawing the map of your civil liberties. I mean, they are going to redefine the actual physical boundaries of your First Amendment right to protest.
And they are going to determine the exact limits of what your locally elected officials can do to protect their constituents.
Exactly. They're going to establish exactly how much raw power federal agents are allowed to exert in your very own community.
So I will leave you with this to mull over. If the current federal government successfully establishes the legal precedent today that it can use conspiracy charges to criminalize state judges and sitting Congress members for defying administrative orders, what happens to the entire concept of states' rights when a future administration takes power with a completely opposite set of political priorities?
That is a scary thought.
Are we watching the permanent erosion of local control, regardless of who sits in the Oval Office?
The clear legal boundary lines we used to rely on are completely gone, and we are navigating incredibly murky waters. So if you found this deep dive valuable, please drop a like, hit subscribe, and share this with someone who loves falling down these constitutional rabbit holes just as much as you do. Thanks for listening, and we'll catch you next time.